Hello and welcome to today's show. Today's show is part 2 on constructive possession, and it is not being performed by a lawyer or anyone who has a hoot and holler of legal experience. Do not take legal advice from people on YouTube. This video is not intended to provide legal advice. Its purpose is entertainment only. It has no warranty, either written or implied, and none shall be inferred. Again, do not take legal advice from old men on YouTube. It's just for discussion purposes and a little bit of entertainment. Now, if one was to look up on the internet the term constructive possession, and one might find someplace like Cornell Law School who might provide a definition such as something that reads something like this: the legal possession of an object, even if it was not in the person's direct physical control, often used in criminal law prosecutions for possession crimes, such as the possession of illegal drugs. Generally, for a court to find that a person has had constructive possession of an object, the person must have had knowledge of the object as well as the ability to control it. Now, let me throw a little fat YouTube guy interpretation on that, whether it might be correct or not. Let's assuming you might be charged with a rolling meth lab possession charge if you have all the goodies you might need to make meth locked up in the back of a trunk, if they can establish, one, that the stuff necessary to make meth is in fact in the back of a trunk of a car you have control and possession of. So you may not actually have the meth in your little hot little hands in the front seat, but if the meth lab stuff is in the back of the trunk and it's locked up and you're in the front and you know it's there and you've got it, it's called constructive possession. They can say that you've got it. Now, let's look at the concept in terms of NFA firearm devices and a well-known 1992 U.S. Supreme Court case. The United States as petitioner against Thompson Center Arms Company. Now, using a search engine of your choice, if you type in United States Supreme Court, Thompson Center, 1992, you can probably come up with this document. This is document number 91-164. The 91, I believe, is the year at which it was petitioned. The United States Supreme Court was petitioned, and 164 was the actual case. The answer was returned 1992 on June 8th. And if you read up at the top, it says United States was the petitioner, Department of Justice versus Thompson Center Arms was the respondent. And this writ is one of a clarification on the law. Now, the second little paragraph there where it says Justice Souter announced the judgment. The judgment was whether or not the tax law, the statute they were using, would in fact require payment of taxes based upon the existence of an NFA regulated short barrel rifle. The next paragraph talks about a firearm, and it's really using out of the section the definition of what a short barrel rifle is, and it's using a portion of it thereof out of section 5845A3, where it talks about the term rifle, and it talks about those basic things that we saw in section 1, or the video 1, where we talked about the difference between Title 26, which is tax law, and Title 18, which is criminal law. And at this date, at this point, it bears out noting that the burden of proof for a civil case for the tax law is a little bit easier to go for than one on criminal liability, because the burden of proof for a criminal action is a little bit harder, a little higher than that of a tax statute. And what the United States is going for is the revenue, is the tax revenue, the $200 tax, and that's what the Justice is asking about. And the next slide, we're gonna step into the history of the case. Now, on the top of this slide, they're starting to talk about the consequences of being a maker of an NFA device. The maker, remember, if you saw the first film. We talked about the difference between being a manufacturer or a maker. Maker is often used in terms of NFA devices, and they're saying that to be a maker, you have to first pay the $200 tax, and that's out of course 26, which we shall be paid by the person making the firearm. They cited before anyone shall make the firearm, they should get permission from the Secretary of the Treasury. It requires a manufacturer, importer, maker register the firearm he or she is manufactures, imports, or makes in a central registry by the Secretary of the Treasury. The maker who fails to comply with NFA's provision is subject to criminal penalties of up to 10 years in prison and a fine of up to $10,000 or both, which may be imposed without proof of willfulness or knowledge, meaning ignorance of the law is no excuse. Now, they talk about respondent TC makes a single shot rifle called, or single shot pistol is what they're saying, contender designed so that the handle and barrel can be removed. It's very modular like the AR platform. The metal frame or housing, trigger, and firing mechanism, and they define that by Title 27, definition of receiver. And they're talking about they made a rifle version. So the whole thing they're going after is if Thompson Center sells a pistol, the contender pistol, and also sells a rifle stock and a rifle barrel, they're contending that they're in fact making an NFA regulated short-barreled rifle and are evading the taxes. I mean, that's what that's sort of the spot, in which case they should be paying the $200 per unit. Now, still laying the background on what brought them to the Supreme Court, in 1985, the ATF advised TC that when its conversion kit was possessed or distributed together with the contender pistol, the unit constituted an NFA short-barrel rifle. Thompson Center responded by paying the $200 tax and filing the application under the tax law, the tax statute, to make, use, and segregate as a single unit a package consisted of a serially numbered pistol together with an attachable shoulder stock and a 21-inch barrel. In other words, they're asking not to make a short barrel rifle, but they're asking to make the package together, a pistol with the rifle kit, because that's what they're doing for one unit. TC then filed a refund claim. After more than 6 months had elapsed without any action on it, the company brought a suit under the United States Claims Court under the Tucker Act, Section 1491, arguing that the unit registered was not a firearm within the meaning of the NFA because Thompson Center had not assembled a short-barreled rifle from its component. And they hadn't. They had a pistol with a rifle kit. The Claims Court entered a summary judgment. That means it's claims court. It's a summary judgment. The judge made a decision that for the government, that means the NFA won, the ATF won, concluding the contender pistol with this conversion kit is an NFA regulated firearm. Now, it turns around, then we went to the next stage was the Court of Appeals, because that decision was appealed. The federal court reversed it, holding that a short-barreled rifle actually must be assembled in order to be made. Are you getting where we're going with this? We're flipping back and forth. It must be made within the meaning of the NFA. The Court of Appeals expressly declined to follow the Court of Appeals of the 7th Circuit in the United States versus Drazen. Okay, now what that is the 7th Circuit had a previous court case that was being argued that it was on point. And that is similar to, and it's in the notes, I believe it deals with putting an extension on the barrel, making it beyond a certain length of suppressor, whether you have a short barrel rifle and a suppressor, or you have a short barrel integrally suppressed rifle. I think that's what that case was. And they're saying because they're the two parts, they're two different things versus together, whether or not you have them assembled or unassembled. And what they're saying here is the Court of Appeals for the federal court said, we're not agreeing to go by what Drazen said. We're doing our own thing. Okay, well, it's on now. because we told them, okay, it is NFA, and then we took them to court, and then we lost that. We won that one, and then we just lost one, and we're going back and forth. So in this one, the NFA provides. So they're arguing that NFA provides. We're still in the background in the decision of the argument. The NFA provides that the term make, because we're going to argue, is a short barrel rifle made when you actually put it together, or is it made when you have the parts, which is the whole kind of the concept behind that constructive possession, yes or no. Okay, and they're asking the Supreme Court, highest court in the land, do we have it like we would have that meth lab example I was going for, when you just have the pieces parts. We were on track to have it as being having the pieces part. Now we just hit a court, the appeals court, that said nope, you got to actually put it together, which kind of makes sense in one way. It's sort of, and they're going to go through. The government uses a bicycle in this third paragraph here, but the NFA provides that the term make and the various derivatives of such a word shall include the manufacturing by anyone other than a qualified to engage in such business of the chapter, putting together, altering any combination of these, or otherwise producing a firearm. And then we got note 2 there. But the provision does not expressly address the question of whether a short-barreled rifle can be made by the aggregation of finished parts that can readily be assembled into one. The government contends that assembly is not necessary. Thompson Center says it is. That right there is your booger. That is your question. The government, Department of Justice, says the parts are good enough. Thompson Center says you got to actually do it. You've got to be guilty. Sort of like you might have the parts to be a prostitute, but Thompson Center says you got to be caught hooking to be guilty of the crime. Government says nope, you just got to have the stuff. That's what this whole theoretical argument is about, and whether or not the law is written to support one side or the other. Now, let's jump down to the third paragraph in this slide. The government analogy of the partially assembled bicycle into a packaged pistol conversion kit is not, of course, exact. What they're basically saying is, okay, I got a bicycle, I buy it like at a Walmart, and I got all my pieces parts. It comes in a big box, but they just took the wheels off of it for shipping purposes. I still got a bicycle, I just don't have it put together. And, you know, they got some good points there. I mean, the government's making a good argument there. You still got a bicycle. It may not be ready to ride, but you still have a bicycle. You just have a bicycle with the wheels off. I mean, that's what Department of Justice is arguing. They're saying that's what we got. Okay? And what they're saying in this paragraph is the distinction, however, do define the issue raised by the government. Argument, whether not the first of which is whether aggregation and segregation of separate parts can be assembled into a short-barreled rifle are sufficient for the purpose to amount to making the firearm, or whether the firearm is not made until the moment the final assembly. I mean, that's it. Do you really have a bicycle if the wheels are off? You can't ride it. The government says, yeah, you still got a bicycle, it's just not fully functioning. Now, I'm skipping a bunch of stuff to hop down to this part in the write-up. The highlighted part here says, but the resemblance ends with the fact that the unregulated contender pistol can be converted not only to a short-barreled rifle, which is a regulated firearm, but also into a long-barreled rifle, which is not. The packaging of a pistol and kit has an obvious utility for those who want both a pistol and a regular rifle. And the question is whether the mere possibility to use the assembled regulated firearm is enough to place the combination of the packaging into the scope of making one. And then we see a note of 6. Neither the statute's language nor its structure provides any definitive guidance. And Thompson Center makes an argument which they basically say doesn't really fall on point. Thompson Center stresses the contrast between the references of any combination of parts and the silence about whether or not the parts in the definition of a rifle, in arguing that no aggregation of parts can suffice to regulate a rifle. I'm not really sure the way I understood this thing to be written that the government bought that, but what they did buy is that the statute is very vague, and since there are some serious criminal potential, that 10 years in prison and $10,000, that we have a real serious issue with this law. Now, in this particular slide, Thompson Center is continuing to have their position described. They try to go into the whole point, the raison d'etre of what the NFA is actually there for, which is regulation of crime, all those wonderful things. However, when you get down to that last little paragraph here on this slide, it says, since Thompson Center's observation on this extraneous issue shed no light on the limits of the unassembled making under the Act, we will say no more about the congressional purposes. Nor are they helped by the NFA's legislative history. Because remember, the law is to be narrowly construed. What's before the court is whether or not the tax law, the tax statute, applies, and whether or not the Thompson Center's pistol, when sold with a rifle part, the rifle parts constitute a taxable NFA item. The purpose of the NFA itself isn't on point. It really has nothing to do with that narrow issue of whether or not constructive possession applies to a criminal statute, or whether or not they have made, according to the tax statute, a short barrel rifle and the tax law applies. I mean, that's what they're trying to get at. They're trying to basically say, don't muddy the water. There's a part in the notes where they refer to the state or the Department of Justice talking about some antiquated revenue rule. It doesn't apply, and they say you mention it, but you don't really need it. And why are you talking about the revenue rule when in fact your position doesn't really apply? Again, they throw it, both sides throw everything but the kitchen sink at it to win their argument, when really it just boils down to yes or no. Have you made an NFA regulated firearm if you have the parts to make one, whether or not they're assembled or not? I mean, that's the whole issue. After applying the ordinary rules of statutory construction, then we are left with an ambiguous statute. The key to resolving the ambiguity lies in recognizing that although it is a tax statute we construe now in a civil setting, the NFA has criminal applications that carry no additional requirements of willfulness. Congress has softened the impact of the common law presumption that ignorance of the law is no defense to criminal prosecution by making specific intent to violate the law an element in certain federal criminal tax offenses, criminalizing willful evasion of taxes and willful failure to file a return. Making a firearm without approval may be subject to criminal sanction, as is possession of an unregistered firearm and the failure to pay the tax on one. It is proper, therefore, to apply the rule of lenity and resolve the ambiguity in Thompson Center's favor. Accordingly, we conclude that the contender pistol and carbine kit, when packaged together by Thompson Center, have not been made into a short-barreled rifle for the purposes of the NFA. The judgment of the Court of Appeals is therefore affirmed. Licensed manufacturer Thompson Center Arms makes a configurable single-shot pistol and offers a kit of parts to convert the pistol frame into a carbine-length rifle. In 1985, BTAFE notifies Thompson Center when its conversion kit was possessed or distributed together with a contender pistol, the unit constituted a firearm subject to the National Firearms Act. Thompson Center responded by paying the $200 tax for one firearm and applied for permission to make, use, and segregate as a single unit a package of a serially numbered pistol with a shoulder stock and 21-inch barrel. Thompson Center later filed a refund claim. Thompson Center filed suit in the U.S. Claims Court after 6 months of inaction, arguing that the combo package wasn't an NFA-covered item because it had not been assembled into an SBR. The Claims Court entered a summary judgment for the government. Thompson Center filed with the Court of Appeals, and on appeal, TC prevailed by reversal. The Court of Appeals for the Federal Court Circuit held that a short-barreled rifle actually must be assembled in order to be made within the meaning of the NFA. In 1991, ATF asked the U.S. Supreme Court for an opinion. It was heard in 1992 and lost. The Court of Appeals stands. It actually must be assembled in order to be made. Important notes. Note number 4. We do not accept the government's suggestion, however, that complete parts kits must be taxable because otherwise manufacturers would be able to avoid the tax. Brief for the United States 11. Rather, we conclude that such kits are within the definition of a taxable item. Failure to pay the tax on such kits thus would amount to evasion, not avoidance. In our system, avoidance of tax by remaining outside the ambit of the law that imposes it is every person's right. Over and over again, courts have said that there is nothing sinister in so arranging one's affairs as to keep taxes as low as possible. Everybody does so, rich or poor, and all do right, for nobody owes any public duty to pay more than the law demands. Taxes are enforced exactions, not voluntary contributions. To demand more in the name of morals is a mere cant. Note 8, and one of my favorites. Justice Scalia upbraids for reliance on legislative history, his St. Jude of the Agiology of Statutory Construction, post at 3. The shrine, however, is well peopled, though it has room for one more, and its congregation has included such noted elders as Mr. Justice Frankenfurter. A statute, like other living organisms, derives its significance as sustenance from its environment, from which it cannot be severed without being mutilated. Especially is this true where the statute, like the one before us, is part of a legislative process having a history and a purpose. The meaning of such a statute cannot be gained by confining the inquiry within its four corners. Only the historic process of which such legislation is an incomplete fragment, that to which gave rise, as well to that which gave rise to, can only yield its true meaning. No. While it's true the Constitution is the kind of the fixed part that doesn't change, and that laws do change over periods of time because the Congress makes them change, that has nothing to do with this right here. What's before the court is, what does the word make mean? It becomes ambiguous. It has become ambiguous. The question is, what does it mean based upon statutory constructs? What does the word make mean? Not what does the whole bundle of laws mean, and therefore we can impart upon the single word anything that we want to contort and twist because what we desire it to make mean today. If we want to make it mean whatever we want it to mean today, then we should have written the law to say it means what we wanted it to say today. That's the problem. That is a very slippery slope. And the problem is we need to write our laws the way we want them to read, not the way we want to interpret them 5 or 10 years down the road because we've maybe changed or tweaked some other law in the family of laws down the road. What's before the court is, what does it mean to make? That's what's before the court. Note 10, another one of my favorites. Now, I'm not going to comment on the left or right leaning of this particular justice. I want it to be a contest to see if you can discern, such as from the comment itself, from note number 10. Justice Stephen contends that lenity should not be applied because this is a tax statute, post at 2, rather than a criminal statute, Post at 1, note 1, quoting Crandon v. United States, blah, 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 blah. But this tax statute has criminal application, and we know of no other basis for determining when the essential nature of a statute is criminal. Surely Justice Stevens cannot mean to suggest that in order for the rule of lenity to apply, the statute must be contained within the criminal code? Justice Stevens further suggests that lenity is inappropriate because we construe the statute today in a civil setting rather than a criminal prosecution, Post ad 2. The rule of lenity, however, is a rule of statutory construction whose purpose is to help give authoritative meaning to the statutory language. It is not a rule of administrative calling for the courts to refrain in criminal cases from applying statutory language that would have been held to apply if challenged in civil litigation. Okay, now just a summary. Lenity means the benefit of the doubt to the accused. So if the law is ambiguous and you're facing a criminal action, it says the benefit of the doubt should go to the accused. From that, do you think Justice Stevens was a liberal or a conservative?